Hello,
Hi.
go ahead, Uche.
All right, great. Welcome, everyone. Thanks for making the time to join us in this chat. Paul and I have had a couple in recent times just chatting again around different issues, including really, we've talked a lot about Julian Assange over the past few webinars. But today we're talking, it's sort of a two-part webinar. And so we'll talk again about, get an update on the case of Julian Assange, but I want to talk about cybercrime in general. And I think there is no more time more trite than today. I mean, the whole world is living on the internet today with what's going on with the pandemic. And if you're dealing in the legal industry, it only takes one breach to become a big significant issue, both for clients and also for the reputation of the parties involved. So cybercrime is certainly a big problem. An example, obviously, is the alleged crimes of Julian Assange, but it's much bigger than that. So Paul, I'm just going to be asking you, the expert today on all of these. So how big is it?
Well, thank you, Uche. Thank you for that, and welcome. My welcome to everybody for coming along. I appreciate it, and I think it's a good thing the law school tries to do. And Uche and I, as Uche said, have done a few of these. Is try to reach out to our alumni and our PhD students and other students, and indeed community at large, and to share some of our interests and knowledge more widely is a good thing. And I hope it's a bit of a two-way street, that at the end you have questions, or indeed take me up on a point, or make a comment. That would be excellent. And indeed, either further on, and my email address is readily accessible on the RGU law school pages. So drop me an email and share your views that way with me would be much appreciated. I've been interested in this subject for some time. My main core interest is in recent years, anyways, extradition law. But before that, it was criminal jurisdiction, and how one act can be criminal in more than one place, I guess, simply. And if that's the case, on what basis and what rules in international law and in domestic law would govern that situation. I think we're commonly in private law, there could be an instance in contract law. Some of you may be studying or have studied international business law or some of the private international law, where one contract or one delict or succession could be touched by the legal systems of various countries. So what are the rules internationally? So that's how I sort of started and years ago now, and then that led me to extradition, and my jurisdiction interest has remained. So that's I'm sorry, my chair is very squeaky. I hope that's not irritating you. That's my background, and I'm not answering Uche's question yet. I'll do it now. But as very close to jurisdiction, of course, is the criminal law, which is, I'm taking jurisdiction from that sense, a public law sense, not a private law. Also looks at jurisdiction in a human rights sense and a criminal sense. So the criminal is, even though I think we could mention human rights, so we will later on at the end, as regards the arguments that Julian Assange is putting forward in his hearing, but mainly criminal law and jurisdiction. Okay, so to get to that, that's a long-winded introduction. Apologies, everybody in Uche.
That's okay, Paul.
I still remember your question, which was how big is it? And these are, statistics are very, a dime a dozen and very easy to find it. But I just thought I'd, give you a couple I found, and there's a UK Office of Cybersecurity in 2011, a little, almost a decade old now, so relatively dated. Suggested that the cost of the UK was £27 billion a year. I assume it would be considerably more than that now. That's, say, 9 years ago. And the Accenture, accountancy firm estimated that it could cost the private sector over $5 trillion in the next 5 years. As I say, there's all sorts of statistics I could put to you, but it's a big problem. And I guess even more recently, I was thinking I've been working with a colleague in Northumbria University, and she went quiet for a while. And it turns out, their computer systems in that university were hacked, and the university was held to ransom. And this was just a couple weeks ago, I think. And a very serious problem. And I think there's other universities in the UK that have been subjected to that sort of cyber attack, where I think that networks are all but shut down, and the institution is asked to pay a ransom, I guess, the fee to have them unlocked. I don't know what happened in Northumbria, whether they indeed paid or managed to sort these systems out. So that's, I guess, one very recent example in the UK and close to home in a university sense, and I guess more widely and relevant again to what's coming up in a month or so, and we could refer to this again shortly, is another sort of cyber activity where individuals are misrepresented or false accounts are created, and attempts are made by states to influence elections. And indeed, there was arguments of that in the Brexit referendum in the United Kingdom, and in the last American election, where Donald Trump became president. And of course, as we all know, if we don't know, we've been sleeping or something, but the next election is in America on the 5th of November. So I've heard a little bit about it, but it certainly hasn't been headline news, attempts to sway people and by false Facebook accounts or Instagram accounts or false news stories, or indeed, this was happening at the same time as Julian Assange's case, the release of Democratic Party emails, of Hillary Clinton's emails around the time of the last election. Yeah. So how big is it? I mean, it's a massive problem, and partly that. Okay, I guess that's it. It's a massive problem. Okay, Uche.
It's really you've actually covered sort of the wide the entire remit of it. It's really huge, and all these examples you've given have significant impacts on there's a ripple effect on the impact of cyber crimes on a large scale, and cyber crimes on a smaller scale, and the lives of even the gentleman just walking down the street. So there's a real impact that is felt on the guys in the lives of the people in the community. But let's backtrack a little bit so we don't get too ahead of ourselves. Just in case, the off chance that there's somebody here who doesn't know what cybercrime is. Let us get down to the basics and just define it. What would you say cybercrime is? How would you define it?
Okay, yes, that's a very good, I guess we noted the scale of it, a massive problem, and then, well, what is it, and how do we define it? And when I'm doing my own reading and research, I mean, there's a library written about the subject already, relatively new, of course. The internet is still relatively new. I think it goes to show the date of me, how old I am in my studies, but I had to read books on the library shelves, and there was no internet when I was studying my law degree. Well, of course, that was 30 years ago, I dare say. And even when I was doing my master's and my PhD, it was just emerging, the internet and email and word processing and Word and that sort of thing. So it's still relatively novel. I think it's become such a part of our lives. We forget that, well, I forget even like 20 years ago, I wasn't using it, but now the first thing I think probably most of us do is, I guess, look at our phone, or you go to work and you log in. I mean, that's what you do. Whereas 20 years ago, you didn't do that. So it's a new type of crime, and massive. And then even in that period, there's been so much written about it because it's so important. But generally speaking, I think most of the writing defines cybercrime as having two parts. One part being a criminal act committed against a computer system. So this would be what happened in Northumbria. Of course, an individual or a group of individuals set out to damage a computer system. And secondly, the computer system is just the medium. It's a crime committed through the technology. So one could be blackmailed, say, through an email or through, hacking into somebody's phone and threatening to release personal photos or bank statements or something. And so that's not against the system itself, but a crime that could well be in before the computer be committed in other ways, over the post. And talking about my jurisdiction studies earlier, when I was reading for my PhD about jurisdiction, that's how many of the cases in the UK started. Somebody posted a fraudulent letter or a threatening letter from the UK to Germany. Famous case about this, and where was the crime committed, in the UK or Germany, or both or neither, and the UK courts thought about this for years and gave a complicated answer. So anyway, simply a crime committed against a computer system or through a computer system. I think that's a simple, basic definition of cybercrime.
Yeah, it's interesting what you said. Obviously, just to keep it straight, Lisa, it's computer crime committed against the computer itself, and crime committed using the computer. So that's it's quite simple the way you have explained it. And it's interesting you mentioned about it being relatively new, and the relevant law governing cybercrime in the UK, it's just about 30 years, I think, and you look at the history of it. Just to add my 2 pence before I ask the next question. In the case of RV Gold and Chevron, at the time it was a hacking case, but there was no legislation to deal with the crime at the time. And that sort of brought about the current Computer Misuse Act of 1990. But I want you to give me an example now, because we've already talked about how big it is and how it's relatively new. So it'll be helpful for people to see how the UK and then also move in a little bit forward from there to look at how I guess this is 2 questions in one. The UK and international rules have attempted to deal with it because like you pointed out, it's fairly new. So how have the UK laws and international laws attempted to govern it, or international rules attempted to govern it?
Okay, excellent. I think I have to be really quite brief because that's a massive subject, and we want to get to Julian Assange before time's out. Well, you've rightfully mentioned the main statute in the United Kingdom is the Computer Misuse Act 1990, and that contains various offences of in essence of both types against a computer system or through one. And I guess the important point I would like to note is in this regard is that even this is back in 1990 when it was enacted, the jurisdictional provisions are quite wide. So, and the main first offense is unauthorized access to computer material. So what we could maybe commonly thought of as hacking is unlawful in the United Kingdom under Section 1 of the Computer Misuse Act 1990. And then there's jurisdictional provisions later in the offense in the act, under sections 4 to 9 that govern whether the UK could take cognizance of hacking, right? And so, because say if somebody was hacking a computer in Canada and they're living in Canada and hacking one there, would the UK be able to and say get custody of the person? Or indeed maybe UK interests were affected. Maybe it was a UK bank situated in Canada. Would they be able to? Well, there's jurisdictional provisions that provide in what circumstances the United Kingdom could take cognizance of an act, and they're really quite generous. And the gist of it is either the individual or the computer affected needs to be in the UK. And that's enough. And so, if one's spitting out spam emails, say, or, that would go all around the world, the UK would easily be able to assert its own jurisdiction, in the event that computers in the UK were affected, regardless of where the individual is. And I'm presently writing an article on aspects of this subject, and of course, and in this in that article referring to a couple of Nigerian nationals who were transferred from the United Arab Emirates to the United States recently, and they got very rich and moved from Nigeria to the UAE. Hush Puppy, I think, was one of the the common names of one of those individuals.
Yeah.
Anyway, so but that person would have been amenable to being tried in the United Kingdom if the UK, if the UK could get custody of him, and that of course turns on extradition law, which we can come to later. But so, anyways, and a good example, the main example of a cybercrime provision in the United Kingdom is the Computer Misuse Act 1990. So that's pretty common knowledge. And then moving to perhaps a more interesting and relevant question from an international perspective, I guess the first point I would like to make is that there's no UN General United Nations Convention on Cybercrime.
Wow.
And I think that's a big point that's worth sort of digesting for a moment, because
absolutely, yeah.
Of course, the internet is global, and it appears, and I think it would be sensible for the true international organization, the United Nations, which has pretty well every state in the world as a member, around 200 or so, that it be the organization under which a treaty on cybercrime is concluded.
So why do you think there isn't any rule at this time? Because obviously it's a big issue, and every country has felt its pinch one way or the other. At least almost every country. So why is that an issue? Why don't we have a UN-driven treaty?
Yeah, there's plenty of explanations out there. I think simply there's a difference in views, and it's turned into a political issue, and that some groups of countries would have an approach that they would want to take, and others would have a different approach. Yeah. And indeed, some countries, I know I just mentioned elections earlier, some countries would suggest that other countries indeed are party to sort of state-sponsored cyber criminality, and and I think that's certainly there's a strong allegations. I personally don't have any evidence of that, but it seems to be pretty commonly accepted that Russia was involved in setting up accounts and acting on social media in an attempt to influence the last American election.
So would you say that it's a question of different ideologies across different regions and a question of trust? And if that is the case, are there regional pacts that deals with it?
Well, yes, that's what's happened. And so, yes, I think that's a good explanation. There'll be other differences. There's different in why there's not an agreement. There's different understandings on privacy law, say. And I think if for us in the European Union and the UK are all now familiar, just because I think every time we go to a website, we have to click on accepting this or accepting that under the GDPR, the General Data Protection EU Origins General Data Protection Regulation. And so EU is taking a leading role in protecting privacy, attempting to protect privacy, where other states have a lot less, pay that issue a lot less importance. And so there are other issues as well. I'm far from exhausted in my explanation, being exhaustive. But so what's happened, I think, what happened even before, relatively early days, I mentioned 1990 for the UK statute. In 2001, the Council of Europe concluded its treaty. The Council of Europe concluded its treaty in 2001, the Budapest Convention on Cybercrime. And so that today is the leading attempt internationally to address cybercrime, concluded in 2001.
What does the Budapest Convention do? Do you want to first of all maybe run beyond the Council of Europe, which I believe would cover most of Europe, but are there other countries who are signed onto that Budapest Convention? Are there other regional pacts that would deal with cyber crime as it affects their region? And you know, what is the importance of the Budapest Convention?
Yes, well, simply there are a variety of regional agreements of various and of nature, very different natures, of course, in different parts of the world, different approaches to the issue, and different provisions. The Budapest, the Council of Europe is often a leading organization in the conclusion of various treaties, as it is on the European Convention of Human Rights, 1950. Similarly, in cybercrime, and unusually, that treaty is open for membership to other non-parties to the Council of Europe. There's 47 countries within Europe who are members of the Council of Europe, but say Australia, Canada, Ghana, Israel, Japan, the US are also party to the Council of Europe treaty. So, and I think it's 65. Last time I checked, I think there's 65 member states who are party to the Budapest Convention. So it's considerably wider. But I guess importantly, from a cybercrime perspective, there are, I say, approximately 200 countries in the world. And all you guess you would need is one or two or three bigger ones that had the technology and the resources that could not defeat the operation of the treaty, but cause a big, spanner in the works. But there are, countries that are commonly thought to be involved in the activity. Russia, Nigeria are not party to that treaty. So that's just, I think there is that international agreement, and it attempts in I think in two main ways to address the issue.
Well, are there regional agreements for those areas? So you talked about Russia, and I believe the cybercrime is one that really, really has no respects for territorial boundaries, right? And the Council of Europe is largely skeptical. How do you do with the Asian, Far East, African? Are there regional agreements that deal with the issue?
Yes, as I said, there are, there's a Shanghai Cooperation Organization dealing with Russia and China, attempting to having some cooperation in and between some Asian countries and Russia, and likewise rules under the African Union to address that issue in an African context. So there are, I think they're less developed. I guess they give the Council of Europe a lot of credit. It is, when it does something, it does it relatively well. And in the European countries that are party to the agreements that it concludes, not that other countries don't act in good faith, but I guess it's probably a matter of good faith as well as resources that and legislative and legal sophistication, and that turns on resources as well, I suppose. Would it be, and indeed come from common legal traditions by and large? I know within Europe there's two main traditions, but such as the last 50 or 60 years in agreements and treaties and various issues that that system is the most developed by some distance.
Okay, let's a couple of more questions before we go into Assange's case, right? What about, let's zoom in on the Budapest Convention, and what kind of offenses, what does it do? What kind of offenses are found in it, and what are the extent of its jurisdiction in terms of its powers?
Okay, I guess those are the, one of the main things that Budapest Convention does is oblige state parties to criminalize acts within it, right? Often criminally related conventions. That's one of the main things they do. They say, and so what happens there is that countries promise each other to make new crimes in their law. Mm-hmm. Or indeed, if they already have them, I guess they would have to make new ones. But if a country doesn't have it, then they would have to enact new crimes, and so that every one of those countries promise each other to not only enact those new crimes or crimes related to computer systems and as a target and as a medium, but also to investigate and prosecute acts that could be criminal under those. So it's not just a legislative process; it's also an executive or a prosecutorial process as well.
Okay.
So there's that, and then jurisdictionally also it provides that the countries, I kind of mentioned this when I talked about the UK statute, agree amongst themselves to apply certain rules jurisdictionally. And say the main one, of course, is territory that the countries agree to provide those offenses that they've agreed. They will prosecute them, and they will be criminal under that country's law if committed in its territory.
Okay. So I get you. Just so it sort of standardizes domestic law and sort of trying to provide some sort of increased cooperation on the international context. But I just want to ask you in relation to an area that you've written extensively on, and that is extradition. Does the Budapest the convention, does it have any provision on extradition, and what's the take on that?
Well, yes, it does. I mean, that's I guess I would say this because that's my area of interest, but a hugely important aspect is that not only do countries make certain acts using computers with computers as targets or means criminal in their own law, but also that they will deem those to be extradition offenses. And of course, if every country that's party to the treaty acts as it's obliged to do in international law, then the double criminality feature of extradition law will be met, right? So, and that requires that a crime be criminal in both countries, a requested and a requesting country. And if the countries party to the treaty act in good faith and do what they're obliged to do, then an individual in one party that uses the internet to commit a crime in another country would be in law amenable to extradition to that country. So it's akin to, like, even in the absence of a treaty. I mean, often we think of extradition requires treaties, but there's a provision in the convention that says even in the absence of a treaty, these provisions shall sort of act in a treaty's absence, act in a treaty's stead. So that that's a good thing, I guess. But I guess then I would say that, okay, well, getting back to the point where there's 65 out of 200 countries in the world are party to it, and I guess something I'm currently writing is I think I say this is that's a good provision. I think that's useful, but it only really can be secondary, and this is what I'm thinking on and writing, is that what really is needed is the country is assistance to the country where the cyber criminals are found, and say Nigeria is not a party to the Budapest Convention, and I'm not picking on it. There's other countries equally culpable, I'm sure, but say in Nigeria, if it became party, then it was given resources and assistance to be able to technical advice to prosecute cyber criminals within its own court system, and such that the law concerning it acts as a deterrent, a sufficient deterrent there. So there would be an immediate possibility of a sanction, and a realistic enough chance of getting caught. But I think we're a long way away from there. Indeed, Nigeria is not even a party now. But that is a long-term thing. I mean, I'm writing about this now, but the long-term solution is not through extradition or extraterritorial jurisdiction, but having agreement within as many countries as possible to criminalize that activity and prosecute it when they become aware of it. Okay, yes, please.
Paul, I just want to clarify that point again, I would like you to shed a little bit more light on it again, just to be sure I understand it. Are you saying that if two countries do not have an extradition treaty, but they are parties to the convention, would it, the question is either of two, does it make them commit to dealing with the case within their national, their domestic laws, or does it serve as some sort of extradition agreement between the parties?
Well, yes, the latter. I mean, so where there's not an extradition treaty between two countries, but both countries are party to the Budapest Convention, extradition is provided for. So, the lack of an extradition treaty in that instance wouldn't be fatal to a possible extradition.
Oh, great.
I mean, there's obviously other bars that will come to Assange's case just in a minute or two, other arguments that could be made. It's not going to be like extradition will be automatic in that case, but it's not prohibited if both countries are party to the Budapest Convention.
Interesting. So that's a good one. So let's just jump over to the Assange's case now.
Sure.
Since we've been talking about extradition, so it sort of fits in nicely. But let's start from the basics again. Just a quick 1 minute chat on who Julian Assange is. I believe everybody does know, but just off chance that someone doesn't know who this gentleman is.
Okay, well, I'll be very short. I suppose there are, recordings of our previous webinar somewhere on YouTube on the internet. So maybe you could find where we discuss this in more depth. But he's I think he was 48, but maybe he's 49 now. Year-old Australian, presently held in London in Belmarsh prison. His extradition hearing that had a big gap in the middle because of the pandemic. The evidence, the oral evidence, just concluded. Written submissions are being made in this case, and I understand it's in early January. The district Judge Breitzer, will give judgment in his case, and she can either discharge him if his arguments against extradition are satisfied or met, in her view, or send his case to the Secretary of State, who has very limited powers to refuse at that point to extradite him to the United States. But there's into the U.S. there's that small degree of political not interference, but a small political role in the process. And so that's what's happening. He's accused in the United States of two types of, I guess we talked about the two types of computer crime. He's accused of both of them. One of them of hacking, of assisting to get Chelsea Manning, of assisting to her, to get to crack a password in a computer system in the United States. And then secondly, so that's sort of directed against the computer system, but then also using computers to, and this is most of the counts, I think 16 of the 17, I think, counts against him, espionage related. So he obtained and disclosed the secrets, unredacted secrets of the United States on his WikiLeaks platform. He was the founder of this WikiLeaks platform.
Yeah, cool stuff. So just against the background, I know you already started touching it in terms of what we have already discussed and how that links to the crimes that are being that he's been tried for. But against the background of what we've discussed about what cybercrime is, you've already explained that and how that fits. But I just want you to sort of buttress a little bit more and perhaps just lead that onto giving us an update of the state of play in his hearing. But how does his crimes, you already explained that, but a little bit more relate to cyber crime and the kind of arguments that have been, made in the course of his trial so far? And what is the state of play at the minute?
Okay, well, a good question. I mean, of course, there's cybercrime related. I mean, Julian Assange is accused of, I think it's 17 counts. One of hacking and the rest of espionage in the United States, and none of those concern him. Setting foot there. He committed, or it's alleged he committed all of them in. I assume whilst he was living in the United Kingdom or traveling around the world, but they certainly don't depend. They don't turn at all on on his physical presence, and they were committed. WikiLeaks is a website, and his communications taking place via email. So clearly, the computers are both were the target of his alleged activity, and the medium of his alleged espionage crimes. And of course, I have to say alleged, and I'm sure hopefully I do that every time. He's presumed innocent, an innocent man presumed innocent, and will only be otherwise if he's extradited, and that remains to be seen. And then if he's tried and convicted in the United States. So two pretty big ifs there. So I think clearly, it's a clear case of alleged cyber crime, but an interesting one in that, his activities were not taken place, or I think the website was not used to, enrich himself. It was not, he was, it's not like we think of cybercrime in other senses where an individual is defrauding other individuals or holding universities to ransom or companies to ransom in order to get rich, to get money.
Yeah.
That's certainly not the case here. It's not alleged here that there was any monetary benefit. So it's please go ahead.
Yeah, I was just going to say that I guess that leads on to some of the arguments that have been levied so far by his team, and perhaps you want to just talk very briefly on that in relation to perhaps politics or human rights and or oppression on the basis of what on the basis of his health or something. So you want to shed more light on those arguments?
Okay, I'll just briefly mention those, and then we can put it out to questions, because we have discussed those. But I guess notable, and I don't know if you mentioned this last time, but notably, jurisdiction and double criminality by and large are not relevant. And so, and we mentioned the Computer Misuse Act before, right? And so I think his hacking, the alleged hacking or the hacking charge in the American indictment is mirrored sufficiently by the crimes in the Computer Misuse Act 1990, right? So we mentioned double criminality, but so that's not, and so the argument, it appears not to be arguable that double criminality is not satisfied. So that's notable, I guess. And here, well, why is that the case? Well, this is between two, his case obviously between two developed Western countries who have taken the roughly similar approaches to cybercrime. Of course, they take different approaches to criminal law generally, with the U.S. being considerably more punitive in the sense of lengthy sentences and so forth than the UK. But they both have these wide computer crimes in their law with wide jurisdiction. Okay. So that doesn't appear tenable. But what you mentioned before, his talking about long sentences. He's charged, and if he was extradited, tried, and convicted in law, I think he's amenable to a possible sentence of 175 years if all the counts. He was convicted on all counts, and they were sentenced to the full on them, and they're served consecutively. So that that could give rise to an argument based on inhuman or degrading treatment or punishment under Article 3 of the ECHR. There's similar arguments that could be made on fair trial, that he's perhaps so notorious, his case is so notorious, and the US's position, and indeed some of the statements made by Trump and the Trump administration politicians are such that an argument could be made, and it has been made indeed, that he won't be able to be tried fairly in the United States in light of that political influence or pressure. So those, I think, probably a couple are the main arguments that could be made. I guess the other one, which may at the end of the day have the greatest chance, is oppression. That UK law provides an individual will not be extradited if it's oppressive on that individual's physical or mental health. And I know he's been in court the past 2 weeks, but there's certainly been reports of him really suffering quite seriously. Indeed, from living in the Ecuadorian embassy for like 7 years or so, but now in Belmarsh prison during the pandemic. So if the judge accepts that his mental health or physical health is such that it would be oppressive, then she can, the district judge can stop his extradition.
Okay, great. Just before we go into our concluding thoughts on this, any thoughts on what's going to happen next in the case?
Well, I guess it will go quiet. We won't hear about it too much, I don't think, until the start of the new year. And I say, my understanding is it'll be on the 4th of January, I think. So I will be, and maybe you guys, if you're interested out there listening to me, and Uche will be very keen to find out what decision is made. But I think that's far from the end of the story, because I think whatever happens, there is likely to be an appeal, and the appellate process could last some time. And the High Court in England would be the first appellate court to hear his appeal, and then arguably the UK Supreme Court, and then even perhaps the European Court of Human Rights in Strasbourg. So this, in a way, I know it's already, his whole story has gone on for over a decade already, I think, but it's not going to end anytime soon. What happens, of course, I don't know. I know that generally the law is such that there's a presumption in favor of extradition, and the arguments against it have to be really quite weighty to succeed. And his lawyers have been making some pretty good arguments, if you've been following it in the newspapers, but whether they're weighty enough, I'm not so sure. So I don't know, but I just wanted to maybe conclude on that point about his case, is that there's a pretty strong presumption that the UK will extradite following a request, and only in very rare cases will that presumption be overcome.
Okay, great. Just interesting conversation so far. There's more questions to ask, but I'm mindful of time, so I'll just go with this one. What do you think? You think it would be possible to efficiently and effectively address cybercrime? You think there's a chance that could happen?
Well, I guess, I don't know. Sometimes I think I'm a grumpy old pessimist, and no, that will never be the case. But I think no, I think eventually, yes, it will just have to be. The problem will become of such a scale. And what I was thinking about when I was thinking about that question is, the development of international law in a rough analogy can be seen in the crime of piracy on the high seas. 200 years ago, piracy was rife, and states got together, and eventually international law agreed that every pirate was subject to universal jurisdiction, and any state getting hold of a pirate could act to try and punish that person. And so in some sense, the cyberspace could be thought of as the new high seas, and eventually it will become in the interest of all states. Maybe other states don't think it is just now, but become in the interest of all states to act. And once we get down to that point, which may be sometime in coming, but once we got to that point, then I think there would be, I think there'll always be cybercrime, but I think down the road there will be more efficient and effective means to attempt to address it.
Great. I think that's it. That's the question for today. It's been amazing.